jurisdiction is seen not only as issuing anti-suit injunctions, but being overprotective in the sense that it also issues anti-suit injunctions to prevent, foreign anti-suit injunctions. I want to ask, for a country that issues such, should it not be receptive to it? Now, the implication of all of this is that China is asserting judicial sovereignty in their area, and it is trying to strengthen its position in global IP cases. There have been a lot of criticisms, perceived jurisdictional overreach, lack of transparency, etc. In fact, the EU dragged China to the WTO in 2021 over its use of ASIs. It doesn't publish its judgment, it doesn't give the basis. There is potential for judicial overreach. It is extraterritorial, as there are so many areas of law that China could issue anti-suit injunction within its own jurisdiction, amongst many others. Some say it's a false friend, others say it's a legal transfer, but there's a whole lot on it. Now, from the proceeding, it's deducible that the world is getting smaller and interconnected, and that disputes transcend the common civil law divide. Some countries issue anti-suit injunctions, some don't. Others issue but are not receptive to it. Now, jurisdictional conflicts in the globalized world are inevitable, but they have to be managed. The sanctity of agreements need to be upheld, while the jurisdictional sovereignty of every nation needs to be respected also. Now, the anti-suit injunction, albeit imperfect, is a tool created to adapt to the mood of international politics. Any other country may, like China, resort to anti-suit injunctions in the face of intrusions from other countries. Whether as a false friend, legal transfer, plant, or howsoever called, every country reserves the authority to protect its jurisdiction. Anti-suit injunctions could work as a shield and could work as a sword. Or an anti-suit injunction could work as a shield as well as a sword. Now, but it's a tool very effective in its use, but it has the potential to be misused. The need for guidelines in its use cannot be overemphasized. Recommendations here: global harmonization to establish international standards for ASIs. We could have object-specific guidelines for ASIs. We could have judicial training and equip courts to align ASIs with international norms. Then the issuance of ASI should be transparent, decisions should be published, and we seek to balance sovereignty and community. Now, this paper calls for a global dialogue aimed at aligning legal and fostering mutual respect between common and civil law systems. As the lines between jurisdictions blur in interconnectedness, the role of the anti-suit injunction becomes more significant. This analysis has underscored their dual capacity as tools to preserve and as mechanisms of national discord. But if we examine application of tools through the lenses of common and civil law jurisdiction, we then gain critical insight to how legal systems navigate the complex issue. The challenge, for me, the challenge lies in reconciling the principles of sovereignty, comity, and the efficient administration of justice. As legal frameworks evolve, the need for greater harmonization and cooperation between jurisdictions, anti-suit injunctions, when applied judiciously, can serve as a bridge, balancing the protection of parties' rights with the broader interests of the international legal order. By so doing, we can move beyond boundaries towards a world where private international law not only resolves disputes, but also exemplifies fairness, predictability, and mutual respect in a truly interconnected world. Thank you.
Okay, 20 minutes now. Recommendations. I think I want to start with the learned sick.
Why? The independent as an out. You wrote my name. Okay. So thank you very much, Adiola. As you know, I have a genuine interest in your work because this is an area that I've done a bit of research and work on because of the importance of private international commercial contracts. Private international. Because your work centers on the first of what I call the tripod principles of private international law. The choice of law about is an important subset of in the context of private international law. So, of course, when I saw your topic, I was very interested in you have and I must commend your industry in terms of how you are able to go through the common law jurisdictions and the civil law jurisdiction. But I have a number of comments, and you know that my comments come from a good place, not so much criticism, but you know, my interest in your work. I really want your work to be exceptional. So a number of comments. So when I read the abstract, I said to myself that, you know, the abstract is supposed to whet somebody's appetite. The person should read the abstract and say, no, I must read this book. And immediately start asking the questions as to, oh, why did you even choose a civil law, common law comparison? And then when I read the introduction, for example, there was really no initial summation of your findings in terms of whether there is a common denominator in the common law countries, particularly England, Australia, and Nigeria, and then the civil law jurisdiction. I didn't see that in the introduction. So I have to now dig into the paper to really try to see what those issues were about. So I think you have to have a look at that introduction again, because it's extremely important that you identify the key points in the entire work, but you already want to feed the reader and suck the reader into your work. Now, this is an area where it's absolutely impossible for any researcher to read everything that has been written in this area. I will consider that any day, anytime. But again, one of the things that I was looking out for in your work was to see the depth and scope of your research in terms of being able to draw the conclusions that you draw, because for anybody who is versed in private international law, it's always a recurring theme, and I don't think there's ever going to be a solution to it. This friction between the perception of judicial sovereignty on the one hand, and courts trying to hold parties to a private bargain. It's always been a recurring thing. So I looked through the paper, and just this morning I said, let me even do my own independent sort of desktop research. And quite a number of interesting articles popped up, which I didn't see in your paper. You know, if you are writing on jurisdiction in the context of private international law or enforcement of judgments, I can't see how you would not cite anything less than 100 articles, okay, to show me that you've read almost everything that is possible, even though, like I said, I know that you can't read everything. This entire paper of yours contains only 29 articles. And you talked about jurisdiction in two major Commonwealth countries, England and Australia. In those two jurisdictions alone, you can have nothing less than 150 articles on jurisdiction and then anti-suit injunction. Not to talk of the US that you also added into the mix. So for me, that was already a problem because I didn't see that you had read widely enough and demonstrated it to me that yes, you know, and part of the abilities of a researcher is that, you know, most of the articles will say the same thing, but there will be some things in some articles that you will demonstrate. So that is one. You really have to improve and expand your people and stuff like that. Now, you make a lot of emphasis on parallel litigation, and I think we've had this discussion before. And I believe that anti-suit injunctions are used and deployed more in the context of preempting somebody from continuing to act in derogation of an agreement as to arbitration. So, you know, your topic, ASI, straddles both foreign selection clauses or foreign jurisdiction clauses and foreign arbitration clauses. And, you know, the rules of enforcing them are pretty much the same. It's exceptional circumstance as a matter of and all those things. So even in your introduction, I expect you to speak more about the instances or the circumstances in which ASIs are deployed. It is not, you know, because, and for me, both my experience in practice and researching in this area and the cases, you would hardly see a case where somebody who asserts breach of a legal right in Nigeria, for example, against an English defendant, that the English defendant will also go to a court in England, commence an action against the Nigerian defendant, because there's no reason for him to. All he will do in that foreign jurisdiction is to go to his courts and say, look, this guy is suing me here. We have an agreement that it is the courts in England that have jurisdiction, so restrain him. So I struggle to really understand what you mean by parallel litigation, and I waited to listen to you this morning. And when you said, it was clear to me that the instances of parallel litigation are actually so limited in the context of your wider discussions about ASIs. ASIs are more of a strategic step by a party to stop another one from acting in derogation of an agreement. He doesn't have any course of action, but he's just saying that your course of action that you are ventilating in Nigeria, not be in Nigeria, it should be in London or be elsewhere. So, and really, that cannot be parallel. You know, so you have to, I think that, and I think I've mentioned it before, that, you know, step down this parallel litigation thing and focus more on the utility otherwise or the issues around ASI in international litigation generally. And it doesn't take anything from your work at all. On the contrary, somebody knowledgeable in the area will take you up and say that this narrow area that you focused on, I mean, is AI truly a principle that is strong on that point? And this leads me to my other point, which is that, again, which I expected to see in the introduction when you're sucking the, is this point about the real role of ASIs, which is in my view, to prevent the continuation of the breach of a contract or the breach of an agreement to litigate in a forum or to arbitrate in a foreign forum. 20, the English Supreme Court in Enke and Chop dealt with this issue of ASIs, the context of trying to restrain arbitration. And I didn't see Enke and Chop in your work. I thought that as the most recent pronouncement by the UK Supreme Court on ASIs, but in the context of arbitration agreements. I didn't take too much of time. You know, as usual, we can have a even in your presentation here, you sort of separated your recommendations from your, but in the main self, why you have recommendations separate and conclusion, and you are almost saying the same thing, you know? So for me, whether you call it recommendation or conclusion, your conclusion just what you discovered and what you feel should be done moving forward. I have my concern. I just don't see how it can work when different countries have different principles, grant of an injunction. So how you can get everybody to apply common rules across common law and civil law jurisdictions. Lastly, you know, again, coming from an point of view, separating, addressing the jurisdiction, you open yourself up to more attack in terms of the depth of the research that you can do on a particular jurisdiction, rather than like isolated incidents. And in your discussion with the US, you then talk about 10 cases and you say empirical evidence to the point. I really struggled with that. Do you remember that part of the book? Where refer to 10 cases in the US and on my phone, but I can't see it here about feedback. And I said, you can't use 10 cases in the US as the US is to demonstrate instances in which the ASIs and instances in which the, you know, the vastness of US and, you know, the independence of their, it's the different. I thought that wasn't a basis to use that as a conclusion on certain findings. It's up to you and your supervisor. In your discussion of the common jurisdictions and the civil law jurisdictions, not so to isolate this heads, but to try and the approach of England and Australia and Nigeria, and the area of these similarities and the impact on the efficacy of ASIs, and do that also in the civil law jurisdictions, you know. And so in your civil law jurisdiction, in Germany, for example, there are instances where in China, rather than separated Germany, you know, to discuss, not to discuss. At the end of the day, somebody can trip you up and say, are you sure that what you said here is truly representative of the German situation? When in your German discussions, you didn't cite any articles. Yes, you said that, you know, but does that give us a complete and accurate view of the provision of law in those countries? You know, but if you just say civil law jurisdictions and you're just trying to demonstrate to feed into your thing, which is that ASIs to you are a good thing, but it's just the balancing that is required between this perception of an assault on judicial sovereignty or not. Last point, you know, you can abbreviate like you do, but what you cannot do is to abbreviate the title of books or the title of articles. So, for example, in your footnote 9, you refer to a book by, and you say the title of the book, the ASI. No, the title of the book is the Anti-Truth Junction. If you look at footnote 44, the article by Michael Douglas, it is anti-suit injunctions in Australia, not ASIs in Australia. You know, so somebody who is lazy, who doesn't go and cross-check, will see your work, and it will start saying, Michael Douglas axes in Australia. The guy will now say, is this my article or who, you know? So you have to be very particular that whilst you can abbreviate for the purposes of your own presentation, you can't abbreviate if the same phrase is the title of a book or the title of an article. You can't abbreviate because you've distorted that person's work. Okay, thank you very much.
Merci. So,
Congratulations. So, this you choose, and that is what you was saying. US, UK, economic research. I see how you struggle to And I asked myself, did you consider maybe approach of a developing country that may have something to offer? Comparing orange, I don't want to change early saying to get you. So you really need a recommendation. You were really better of just illusion and be done to. Is like of and China, so that a potential between Nigeria and China is in the context of national commercial that have Beijing as they agreed. That is a purely commercial and a dispute that, for example, relates to admiralty because of our own mandatory local allows Nigerian courts to assume jurisdiction. So would a Chinese court, based on what you've discovered about their rules, still injunct has instituted an action in Nigeria on the back of a statutory intent? Or would, because of the recognition of Nigerian laws, the Chinese courts will, as a matter of committee, grant this injunction? That they probably would have granted jurisdiction where they don't have mandatory. That's the analysis that I want to see in your work. You know, so for me, you will still achieve the same thing by just dealing with Nigeria, England, China. Your discussions about the German ones, and you put them in a footnote. You put them in a footnote that, you know, what China, civil law jurisdiction, see similar things, or is different. Germany, Two footnotes. You add up one, but China, that there's a lot of activity. the trade relations between Nigeria and China justifies you talking to China and letting us know and Nigerian businessmen understand the implications, the legal implications of jurisdictional questions that disputes with China. One last point. In fact, I just remember I wrote an article on anti-suit injunction in London. Yes. Thank you.
No other comment. I think on that note, we have listened to the very useful contribution of the two professors, and they have my professor, the two supervisors, and the candidates. We are going to work on our paper. Well, oh, she's expected to respond before me.
Yes. Nobody round up.
Yeah.
That's strange.
Not to respond.
Usually we don't. Well, thank you so much, sir. I will ensure that all the highlighted points are taken care of. The only part that I found a little, I really goofed that part of the textbooks. I did auto. I just did, and I did not check the footnotes. So everything that had anti-suit injunctions, apart from the first one, I checked the ASI, because Prof highlighted it and said, apart from the first one, I should write ASI in brackets and that make it consistent. So I did not look at it. And when Prof said it, I was confused. Yeah.
That please read those documents at your final check of any work. Don't read the work, read the work for. Just sit down the footnotes. Footnotes are the way of deceiving you. So read the footnotes alone. That will help you. But they also go to comply with the reference guide. So when you do that revision, that will help you.
Thank you so much.
So I was talking as a supervisor, and I was saying that on behalf of myself and Professor Oke, that Professor Oke didn't eventually join. I don't think so.
I joined. Thank you.
That we have taken cognizance of the comments and we will guide that to do the right thing. Professor Oke, any word from you?
Just to appreciate everyone for their time and commitment, despite the fact that we are all in another mood for Christmas. Thank you. Thank you. God bless.
Thank you.
So in my capacity as the chair, we move on to the next presenter.
Sorry, sir. Can I just congratulate the first presenter before you move on?
Okay, doctor. Yes, I saw that you wanted to say something.
She's my sister. I must commend her now. I want to congratulate you, my dear sister Laja. Well done. She's been a tenacious person, and I'm so happy that this is happening before the end of the year. So I believe she's going to work on all the corrections that have been highlighted, and she's going to make a better paper. Thank you very much. So I'm waiting for, all right.
Okay. Thank you. So,
thank you, sir. Good afternoon. All right. Good afternoon, professors, senior colleagues, and their colleagues. Topic of the presentation is strengthening regional and sub-regional ties towards the development approach, international jurisdiction approach, tourism. And the content of the seminar paper was introduction, which
discuss and speaks about the effect, the efforts that have been deployed so far on the introduction or the proposal or the proposed plan to introduce the concept of universal jurisdiction on the offense or crime of terrorism. And I tried to highlight international initiatives on this particular discussion. Also, I talked about regional initiative. I also looked at some sub-regional initiatives and then looked at bilateral relations. And then the concluding part of the work also provided some form of recommendation on the usage of international criminal law and the universal UCJ. Now, on the abstracts, I note here that the philosophical underpinning of the universal criminal jurisdiction is the prosecution of crimes. In the prosecution of crime are justice and dignity for the victim of international crimes and crimes that share similar characteristics. Now, undoubtedly, universal criminal jurisdiction, which I will now refer to as UCJ, serve as a medium for international criminal law to remove the veil of impunity from perpetrators of international crime, and then the full implementation of the principle of universal jurisdiction on terrorism has remained difficult. Now, specifically, this paper examines the involvement of regional and sub-regional and intergovernmental institutions in the mission to develop a universal agreement for the fight against terror. Now, the paper found, among other things, that regional and sub-regional operation is more valuable to the cause of overcoming terrorist impunity, since a multilateral approach to the problem has proved to be extremely difficult. Now, on the introduction properly, terrorism has remained one of the biggest and the most challenging threats that the world is facing at this time. And the determination to challenge its existence and prosecute those who are involved in it has also, triggered in recent past, been triggered by solidarity and common interest between countries, and that we've seen that the crime or the offense of terrorism is one that constitutes a threat to the entire human race. Now, the global fight against terrorism has encountered significant challenges, some of which have to do with the issue of the inability to generate a definition that is generally acceptable and to be able to define the cause of the crime. And looking at what universal jurisdiction is all about, it's been said that it's a legal principle that allows or requires a state to bring criminal proceedings in respect of certain crimes, irrespective of where such crimes were committed, meaning that the border will not stand like a barrier in prosecuting such cases. Now, the concepts of crime against humanity provide the foundation for the idea behind universal jurisdiction, and at the same time, to the mind or the plan to attach or to terrorism under the crimes that can be prosecuted under universal jurisdiction. Now, in the first, it's global effect. I'm talking about terrorism now. It can now be correctly characterized as a global issue rather than a domestic issue because of the effects it generates to the entire world, in general. Now, this research observed that regional and sub-regional organizations are well positioned to understand the root causes of terror and provide support actions and cooperation in addressing the menace of terrorism. The UN, through its Security Council, 15th of 2021, aligned the importance of utilizing the existing and potential capabilities of regional organization in taking to the crime of terrorism. Now, I'll move to look at the international regional collaboration in order to be able to establish the point that is being discussed here. Now, in general, collaboration is defined as agreement two or more parties to work jointly towards a common goal. For collaboration, cooperation, and political and economic integration dialogue among state geographical who are far apart. Whether but particular crime as a same as a of the international community. Now, of the collaboration of justice, favor and the usage of universal justice in terrorism crime that affect totality of the regional collaboration in this part. First, I will say the UN again. Now, the UN is the world's largest organization, international organization, and since creation, UN has more than any other international show major support for terrorism. What of the UN in all four. Now, I have an example here. Number one is the adoption of the counter-terrorism strategy. This particular point, which is one of the UN unique global instruments to enhancing national and regional and international effort to counter terrorism by consensus in 2006, the UN members agreed to a common strategy and operational to see prison. June 23, Assembly agreed without even a vote. Resolution 298. 8th of the United Nations Global Terrorism Strategy. Thus, around the strategy and consequently led to a pillar of the United Nations counter-terrorism strategy. The story for this paper is measured to address the issue conducive to the spread of terrorism. Pillar 2, measure to combat terrorism. While Pillar 3 measure to build state capacity to prevent and combat terrorism to strengthen the role of the United Nations. Fourth pillar deals with the measure to ensure respect for human rights for all and the rule of law as the fundamental basis of the fight against terrorism. Another initiative that the UN has introduced is the formation of the UN Office of Counter-Terrorism. Now, this office is saddled with the coordinating reviews and accepting submission from member states and regional organizations, and to see how they are able to contribute to the fight against terrorism. And the recent review that was done was conducted sometime in January 2021 and December 2022. Also, part of their initiative has to do with the Security Council resolution on counter-terrorism measure. And the Security Council at regular intervals usually make resolutions in pursuit of countering terrorism at all levels. The fourth one is the capacity building project in member states. Now, in year 2021, the United Nations completed a joint system-wide evaluation and oversight report, and it also launched counterterrorism early warning network for Central Asia to address terrorism, and at the same time, it has trained about 4,500 criminal justice and law enforcement officials in more than 70 countries, around the world. Now, in looking at the African Union initiative, we've seen that despite the global effect of terrorism, terrorism has continued to show a particular intensity in Africa. And of course, today is still expanding because of the development of the key actors like the Al-Qaeda, the Daesh, even the Boko Haram also has contributed to the widening effects of terrorism in Africa. And this development has suggested that beyond the direct military response and also structural issues such as political instability, weak state capacity, and all of that, all of those has created a fertile ground for terrorism to thrive. And recognizing these challenges, the AU, building on the past achievement of the OAU, has sought to establish a comprehensive counterterrorism framework, which tends towards putting or limiting the effect of the menace of terrorism around the world. So AU and its predecessor SPARS Convention set the tone for establishing a common front or regional jurisdiction on terror. As a matter of fact, Article 4 of the Constituent Act of the AU echoes this sentiment. On African Union counter-terrorism framework, there is a long history of regional ongoing effort to prevent and combat terrorism in Africa. I've said earlier, the effort of OAU in time past, also with what the AU is doing presently, in so many ways, through what we refer to as high-level intergovernmental meetings, have provided plans or adopted even plan of actions in preventing terrorism, within the region. And AU also created African Modern Law on Counterterrorism as part of the implementing the pertinent provision of the 2002 AU Plan of Action on Preventing Terrorism. Now, I'll move quickly because of my time to the bilateral relations as relates to the subject of discourse. Now, importance of bilateral relations, we know that a particular country cannot on its own fight this war successfully. So there is need for proper collaboration between other countries who are around them in order to achieve the purpose of bringing the menace of terrorism to and to reducing its effect on the world at large. Now, we have part of this bilateral point or effects or action that have been taken to include bilateral extradition treaties. Also, I have mutual legal assistance. Countries all over the world collaborate to see how people involved in this act are not allowed in any form to escape justice by providing mutual assistance in their fight against the crime. We also have features like joint security operations and also even providing needed assistance to ensure that the country that is fighting this cause directly has the sufficient power to discharge the duty that is placed upon it. And the papers generally recommend that there is need for the sub to be further discussed and then to see how the region can, develop a legal framework to ensure that the region, countries are able to fight the scourge effectively. We have harmonization of laws as part of the recommendation or invest in capacity building initiative, strengthening international judicial bodies, and promote continuous dialogue and sharing of best practices. In conclusion, the importance of legal framework that is dedicated to prosecuting terrorism under the principle of universal jurisdiction is both pressing and indispensable. So therefore, universal jurisdiction is justified on and as it embodies global community collective condemnation of terrorism. And on the legal aspect, it aligns with the principle established by international law, particularly in prosecuting crimes that threaten international peace and human rights. And the paper focused on the fact that regional organizations like the EU play pivotal roles in ensuring that the fight is on. Thank you very much. That's the end of it.
My brother Olabiton for the I want to join others in congratulating you on this paper. And just my only two comments to do with and the Olabiton. Before now we had time is or it's already in the paper you have given us, and all you need to do is you are the author of the work, and you know the points that you to when you are the and to say that correct from the one that received of so,
Dr. Adedi, go on, please.
All right, thank you very much. Let me join every other person to congratulate Mr. Olabinton. We thank God for seeing you this far, and we trust that this will be the final leg towards achieving your dreams. Now, I will make two comments. One, I'm trying to open the soft copy also on my system here. The first one is I want you to go back to your numbering. You need to work a little bit on your numbering on the structure because it's a bit confusing. You know, numbering will make work reading flow. You will know that you are discussing something under a subtopic. For instance, let's go to your definitions of terms. Your definitions of terms, you wrote 1.01. Now, is your definition of terms under your introduction, which is 1.0? So if you're talking about definition of terms, if we agree that it's 1.01, your next one, definitely when you are defining the terms, terrorism is part of the terms you're defining. So you now put it as 1.1.0.2. The next one, you put it as 1.0.3. So it's a bit confusing. Same thing if you go to your 2. Under your 2.1, you wrote United General Assembly, something. And the next one, I think you now wrote 1.1, Pillar of the United Nations Global Counter Strategy. If you go on like that, I saw quite a number of them. If you go to your 0.3.0, after that, it's a little bit confusing for somebody that wants to read and follow. That one is just on the surface of the book. Then another thing, looking at your topic, what came to my mind, you've done a good work, but I look at talking about terrorism. You're talking about all the collaborations between the international bodies, regions and sub-regions. You talked about AU, you've talked about ECOWAS. I just came to my mind that probably you should give attention to some of the challenges, some of the things that will make these collaborations a bit difficult and maybe a limitations to some of these collaborations. Now, how do I mean? I'm thinking of Burkina Faso, I'm thinking of Mali, I'm thinking of Niger. Those people, you know what is going on in those three countries, particularly concerning ECOWAS. Are they leaving ECOWAS? Are they part of ECOWAS? Is it possible to still have collaborations between those three countries, having military head of state? And it's not only that those countries, there are also sounds of rumors of there could be coup in some other countries. Are these not some of the challenges that is going to affect collaborations between affects regional collaborations and sub-regional collaborations? So I think it may be good if you can find a way to talk about those limitations and challenges that's going to affect the collaborations in terrorism when it comes to sub-region or regional uh, level. Particularly knowing that some of these countries are very red zones. Talking of Mali, talking of Niger, particularly when you look at it vis-a-vis Nigeria, we know that a lot of these places are the breeding grounds for terrorist groups. So how do we collaborate when they're no longer part of EU, AU, part of ECOWAS, etc., things like that. So that's just my little contribution. I once again congratulate you, Mr. Labington. And like I told you earlier in the day, that the Bible says that he crowns the year with his goodness. This is what we call the 11th hour blessings. Thank you.
So, I think, and thank you for the spiritual dimension of your discourse. So, okay. Can it be white? She's not unlike. Oh, okay. 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 It has to be one. Yes, yes. I invite the candidate.
Thank you very much, sir.
Don't forget.
Okay, thank you very much, Prof. And for all our senior colleagues that have made their contribution. I would like to appreciate the comments that have been provided. And I promise that I'm going to look at the work all over again, incorporating all the suggestions and the points that have been made to make the paper a better one. So once again, thank you, and I say amen to all the prayers that have been said. Thank you very much.
Okay. So,
those who came online and those who all our well wishers, all will be well. Thank you all very much. Thank you. Thank you.
so on that note, I thank all of us for our presence, whether physically or virtually, and I declare the program closed. Thank you very much.